I'm Shanna Welsh-Levin with SoCal Realty Law, and welcome to our monthly webinar series. Usually we do something about what landlords need to know, and this is still in line with that. Today we're going to be covering short-term residential occupancy licenses and permits in San Diego County, and particularly we'll do a deep dive into the city of San Diego and its new ordinance. Just a little bit of housekeeping. We are recording the webinar today. It will be posted on YouTube. However, your faces and your names will not be part of the video. We do have the video edited so that those things are removed. It's just going to be my friend Dennis and I who are presenting today on YouTube. So no worries there. You are welcome to post questions in the chat. Rather than stopping throughout the webinar to answer questions, we like to wait till the end, and we'll save hopefully 10 minutes at the end to go over some questions. And then if we don't have time to get to all of the questions, I will write out the remaining answers and send them out. After the webinar, you will all receive the link to the YouTube video, as well as a free resource, which is usually, my slides and maybe an article or a table or something that you either request in the chat. If you want a copy of something, we can send it to you as our free resource after the webinar. So I'll introduce myself first. Shanna Welsh-Levin. I did say that already, but I am a real estate attorney with SoCal Realty Law. I've been a real estate attorney for 18 years. And in April 2020, I wanted to become a resource for all of the landlords who I knew would be impacted by COVID. And then the laws were changing so rapidly that we had lots of material for monthly webinars. Now that the moratorium has pretty much tapered off, we have other things that we are presenting on, such as today's topic, the short-term residential occupancy. And when I have to learn something new, I always like to put it to good use by putting it in my webinar. It makes me do a deep dive into the subject, and then I like to share it and continue to be a resource and add value to our community. Lately, we've had clients who required us to help them with these license applications for short-term vacation rentals. And so I've learned a lot. And I want to introduce you to my friend, Dennis Stryker. He is my attorney, colleague, friend, somebody that I look up to because he does these great transactions. He does transactional and land use. So he's going to assist me with this webinar today. And I have invited him to assist me because he is also a naturally curious individual like me. We began having this lively conversation about the short-term licenses, and I think that he has some really great insight about this. So Dennis, as I started to mention, he is a real estate attorney. He is with Stryker Slev Law Group. He practices in the specialized area of land use and development. He works with his better half, Monica Slev, who handles construction defect litigation and contractor disputes. And Monica is here today too. So to get started, I have a few slides for you. So there are a number of cities in San Diego County that are currently regulating short-term residential occupancy with licenses and permits. These are Solana Beach, Carlsbad, Del Mar, Encinitas, and then on May 1st, 2023, the city of San Diego will begin regulating through licenses, and all of the license applications are open for that, but they're not required in the city of San Diego yet. They are required in Solana Beach, Carlsbad, Del Mar, and Encinitas. So if you go to any of these city websites and you put in short-term rental, the information on their policies will come up. And Dennis, you mentioned that there's a city that's not allowing short-term rentals at all. Where is that?
So pretty much, as one might expect, the city of Coronado actually prohibits rentals for less than 25 consecutive days. And what's really interesting about theirs is you cannot have a short-term rental in any residential zone within the city of Coronado, which pretty much is most of the island. There's only a short portion of Orange Avenue that really is the commercial zone, and everything else is pretty much residential. So they've become extremely restrictive in Coronado. And just so you know, the reason why you need to pay attention to Shannon today is the city of Coronado actually went after a resident who owned a house and fined them $10,000 for violating their ordinance.
$10,000. That's crazy. I think that they should appeal that and see if they can get around that. That's incredible.
Yeah.
So what about all those hotels on Orange Avenue? Those are short-term vacation rentals, but how are they different from somebody who's trying to rent out a house?
Well, so the hotels and motels are typically in especially in the city of Coronado, but in other areas too, are in commercial zones. And they actually comply with other city ordinances. If you look at city ordinances for the city of San Diego, or any of the ones that are listed here on Shanna's slide, you will find that they have special ordinances designed specifically for hotels and motels. And they have a totally different licensing program, an entirely different system with regard to what's required in terms of construction, life safety, and a whole host of other things that you wouldn't find in if we rented our house, you wouldn't find in our house. So.
Got it. So it's that zoning and it's those building code requirements that make a hotel and a short-term vacation rental a short-term vacation rental. Was that fair to say?
That is fair to say.
All right. I think I just learned something. A few nuts and bolts about the city of San Diego, because we really can only do a deep dive into one of these cities. And the city of San Diego is hot right now because it's new. All these other cities have been doing it for quite a bit longer than the city of San Diego. So in particular, we have this timeline. This is taken right from the city's website. They are open for applications on all 4 tiers. They have tier 1, 2, 3, and 4, and we'll go through the definition of those tiers in a moment. The tier 3 and 4 license applications are due by the end of this month. So we're working on a bunch of these, and they're not the simplest things to figure out. I've had a lot of communication back and forth with the STRO desk from the city. They have a special email hotline, telephone hotline. I don't recommend making an appointment to talk to them in person, because the person who gets on with you in the in-person meeting is not going to be from the team that's answering the emails and the telephone number. So just learn from my experience. But the email is very effective and they're very responsive. And as I mentioned before, in the city of San Diego, if you don't have one of these 4 tiers of license by May 1st, 2023, then you are not allowed to do short-term vacation rentals. The way that they will catch you is that you will generally have to advertise on a platform such as Airbnb or VRBO in order to, get your renters in. And the city is monitoring those websites and auditing those websites to make sure that transient occupancy tax is being paid. And then once the licenses are required, they will certainly use those same resources to enforce the new ordinance. There are fees that have to be paid for the applications, as well as when you are awarded a license, there's an additional fee that has to be paid. And tier 3 and 4, well, it says that all hosts are selected in a lottery basis, but in particular, tier 3 and 4 are going to be the most competitive. And so, it says a lottery, but it's a weighted lottery, and we'll go through some of those details. So more on the city of San Diego. Tier 1 is where you are renting a room or an ADU part-time, an aggregate of 20 days or less per year. This is where the owner lives on site and shares the property, the parcel. Tier 2 is home sharing, where you're renting a room or rooms more than 20 days per year. Actually, no, I'm sorry. I said this wrong. Tier 1 the owner does not have to occupy the property, but the property cannot be rented for more than 20 days per year. Tier 2 is where the owner has to reside on site. The rental can be more than 20 days per year. The owner may be absent up to 90 of those days. And the interesting part of Tier 2 is that it includes duplexes and ADUs. So we're talking about, a parcel that has 2 units, maybe 3. Well, let's stick with 2 units. So if there's a home and an ADU, when the owner lives in the home, then you can get a Tier 2 license to rent out the ADU as a vacation rental. And it's not as competitive for Tier 2 because they haven't stated any limitation on how many of these licenses the city is going to give out. Moving on to the whole home licenses, which are the Tier 3 and 4, these are licenses for homes and units, apartment units, condos, where the owner does not reside on site. This could also be an ADU or duplex where the owner does not reside on site. The host, the person applying, it says owner, that's not accurate. The host is the person who applies for the license, must be a natural person. Guests under this ordinance have to stay at least 2 nights. And in particular, Tier 3 is for this very small area of Mission Beach. It's the Mission Beach Coastal Zone, or what is it called? The Mission Beach Coastal Community Zone. They're only issuing licenses for I'm getting this confused. Tier 4 is the Mission Beach Community Planning Area. They are allowing licenses for up to 30% of the residential units in that Mission Beach Community Planning Area. It's a very small area along that strip of land between PB and basically the jetty. Tier 3 is the area of the coastal area around Mission Beach and north and to the south within the city of San Diego, and they're only issuing the short-term licenses for 1% of that housing stock, and that's throughout the rest of the city of San Diego. So the only exceptional area is that Mission Beach area, and then the rest of the city, if you're going for a Tier 3 whole home application where you don't reside in the property, they're only going to allow 1% of those properties to have the licenses. Okay, other interesting points on this. If you have an apartment building where you've got lots of rental units on a single parcel, we're not talking about condos, we're talking about, actual apartment buildings. There are no restrictions on how many licenses can be on a parcel. A parcel can have only 1 residential unit business tax number. So a residential unit business tax number may be used for multiple units when you apply for these licenses. However, the applicant, the host, must be an individual, can't be a corporation, and a host can only hold 1 license. Here's where it gets interesting. The host could be the owner of the property, or it could be a tenant at the property. If they're a tenant and they're applying, then they have to have a lease that allows for, it has to be a written lease that's submitted with the application. It has to allow specifically that the tenant can sublease for less than 1 month. Now, if you have an apartment building and you find that you have multiple tenants, or you create a situation where you have multiple tenants, different people who are going to apply for these licenses, you can have one central property management company handle the rentals. So the property can be managed by a corporation on behalf of the host or hosts, and the local contact for the city does not have to be the applicant. It can be a property manager. So one way for these owners who have made a business out of short-term rentals around San Diego for them to continue to be in business is to figure out how to get individual tenants, how to lease to individuals, to get all these individuals to apply, and then to have their property management company manage it. Okay, so in applying for the licenses, there is good actor prioritization. And I'm going to ask for Dennis's participation here. So the good actor prioritization is one of the most interesting parts of this, because the idea is that it improves the probability that good actors will receive a license, but it still provides an opportunity for a license, for licenses to newcomers in the industry. So here's how these folks who have been actively involved in short-term vacation rentals get a little bit of leverage to get these licenses. So they have, if you can show with your application that you are in compliance with transient occupancy tax registration requirements, you get a point. If you as a host, you have verifiable proof of more than 90 days of booking activity during the previous however many years, you get extra points. And if you have more years of proof that you've been doing the short-term vacation rentals, you get more points. Hosts that have verifiable proof of actual payment of transient occupancy tax get even more points. And depending on the more years you've paid it, the more points you get. And then we have this issue of hosts operating during the previous 2 years that have no verifiable code violations during those years. So, Dennis, how do you think they're going to measure that, those code violations? What do you think they're going to do there?
Well, it's interesting because they talk about verifiable code violations. And in the ordinance, it talks about the city manager having the ability to punish those that have licenses various ways, to send, written warning, show violation. There are fines, or they could actually revoke your license. But this doesn't really tell us what we're talking about in terms of what a verifiable code violation is. And are they talking about the entire municipal code, or are they only talking about code violations associated with the Licensing Act under the short-term system? And that's what's kind of confusing with regard to this, is we don't really know where these violations are coming from. Is it you left your car sitting out on the curb and your neighbor doesn't like it and has been there for however long the ordinance limits you to before you're supposed to move your car in the city of San Diego? And is that going to be a violation that affects your ability to use your short-term license? I don't know. This is not well defined, and it seems to be a bit arbitrary in terms of how these extra points may be distributed.
And so if you review the code, if you review this particular code on short-term occupancy, do they expand on what they mean by this?
They don't. This appears to be more of a policy that the city is going to use for determining how it's going to deal with the lottery system, because it's really not built into the code that tells us what it is the folks that are going to be applying need to be able to comply with, other than we see these 4 things sitting here that tell us how many you get extra points, but it doesn't really tell us what happens otherwise. So we have a lack of definition.
Mm-hmm. And if I am an owner with code violations, would I know that I have code violations?
Presumably the answer to that is yes, you would know you have a code violation. In the city of San Diego, the way the city issues code violations is they typically will mail something to you that tells you that it's code violation. You have X number of days or X number of months or weeks to address that code violation. If no one's around or no one addresses it, they literally sometimes will do the age-old knock on the door and then post it on your door that you've had a violation. So you should know about that. However, we're talking about a city whose system of tracking everything and anything is woefully outdated. So it's possible that one could slip through and you wouldn't know.
And what if I had a code violation and I fixed it? And I was a good actor because I couldn't control what these people did at my property. But as soon as I found out about it, I took care of it. You think I might get points for that?
Well, you don't get points for it, I don't think, but because they're talking about no verifiable code violations. But I also think that the city understands, at least much of the city understands, that violations happen when you are an owner and you're renting to other folks. Other folks may do something that you don't always have control over. A lot of times those violations may actually be taken off your record, if you will. So it might actually help. I mean, if you do things right, it should help you.
Yeah. And I wonder if it's you either get all 3 points or you get 0 points.
Well, that's interesting because here it only has 3. And if you look at the other 2, you get either 1 or 2 or 3 points. There's a very, there's the ability to get more points. And this one, it just says 3 points. And I don't know if you get, I had a violation, so they're only going to give me 1 point. I don't know.
So assuming I am a new short-term vacation rental owner or landlord, and I am just applying for a brand new license and I have no history, then I start this process with 0 points. And an owner who's been doing this for the last 5 years or more starts with 10 points. So who do you think would get the license? I think that's obvious.
Well, yeah, I think it's pretty obvious. And the question that I have with regard to that is, why are we creating this system of adding additional points as you get weighted priority in order to get your license, unless building into the concept of the Licensing Act itself is to try and contain the licenses that are going to go elsewhere to go to the folks that they already know and have a quantitative idea of what's going on with those particular operations. I mean, I don't know that it allows newcomers into the industry very easily.
They also seem to be very flexible with allowing people who have been doing this with multiple units to, I'll say, finagle this idea of, if a host has to be an individual and the property is owned by an LLC, you find friends and family who will sign a lease and then you apply on their behalf. And that leads me to, the next big question that I had when assisting with these applications is, can you use, if you have like a property management company that's already been managing the property and doing these vacation rentals, can you just continue to use the same transient occupancy tax number that you've been using for multiple units over multiple years? Or now do you have all these individual hosts who need their own TOT number, TOT account? It was an interesting, I should have gone to fix this this slide because the way that it's written is a bit confusing, but I did present this question to the STRO desk and was told that a TOT, depending on how it was created, it may be used for multiple units. This slide says parcels, but I believe the way it should have been written is units. And this is copied and pasted from the answer that was given to me from the city. So not very clear, but they use the example that in cases of a duplex, triplex, etc., the TOT operator may have established one TOT certificate for all properties on the same parcel. And I think they mean all units on the same parcel. And so that was intended to be an example of how one TOT certificate might be used. But then in another example that I don't have copied here, it was suggested that, let's say the TOT, the property management company has a TOT number 11, and it's managing for owners that have TOT numbers 22 and 23. The property management company number 11 would submit TOT payments, transient occupancy tax payments, for numbers 22 and 23. So it would have to tell the city that it's submitting tax for these other 2 TOT numbers. And that contradicts the answer that was given to me here. So I do have an email to the TOT administration for some clarification on this, because I don't think I got a good answer on this. Do you have any insight on this?
Not specifically, but it does make more sense that if you have a number of units on a piece of property and you've already got one TOT certificate, that there'd have to be a way to differentiate the TOT that's associated with that which is short-term rental and that which is not considered part of the short-term rental. So if I have a property, I've got an apartment building, I've got 14 units, and I have one unit that I have as short-term rental because that's all I can have, then you'd want to make sure that you have a way to differentiate to show that you're in fact complying specifically with this ordinance. So you may want to ask for a separate certificate for that particular unit. It gets complicated, and I hope that the administration gives you some further guidance because they've not done a good job of informing all of us how they really want us to apply and pay over the tax.
Yeah, I definitely am feeling a little bit of pressure because if more TOT numbers have to be obtained, I'm not sure how long that takes, but hopefully they issue them fairly quickly. Okay, so then there are two numbers, they are tax account numbers. One is the TOT account, and the other one is the residential unit business tax, the RUBT account. And the RUBT accounts can be used by multiple unit owners because the RUBT account number is assigned by parcel. So if you have multiple rental units on a single parcel, these are apartment buildings, not condos, because condos have different parcel numbers, but apartments do not. The hosts that are in apartments can use the same RUBT number for the parcel that they're on. All right, so I've found a couple of loopholes and opportunities, and Dennis, you can jump in and help me with these. These are just things, out of my head that I think, people might want to focus on if they're looking to do more vacation rentals. Tier 2 includes ADUs. This is where the owner lives on site. There are seemingly unlimited licenses available, and so less competition. I think the question that I have at this point is whether it could be more than 2 units on a parcel. So tier 2 specifically is defined as renting a room or rooms in the home for more than 20 days per year, so long as the owner or permanent resident resides on site. The owner or permanent resident may be absent up to 90 days. Home sharing includes duplex properties and eligible accessory dwelling units when the host resides on site. So eligible accessory dwelling units, it doesn't say one accessory dwelling unit, it just says eligible. So potentially if you have your home and 3 accessory dwelling units on site, couldn't you have 3 tier 2 licenses for your property?
So I think that what happens is you treat the license as a license for the property, and you're just able to rent out those additional ADUs as if you were renting out. Let's say you have a large 5-bedroom house, and you've rented out 3 of those rooms to 3 different people during the month of July. And that you only have one license, you only need one license, but you have 3 bedrooms and you've rented out to 3 different people that are not family members of each other. That seems to be workable. That's not what the ordinance seems to govern. And I think that you're right. You could end up renting under one license on a property, those 3 ADUs is because they fit as if they were 3 bedrooms.
Yeah, I think it's a little bit vague though, because you wouldn't want to get caught doing it wrong. And then I have already talked about, identifying multiple hosts in a multifamily apartment building. So giving these hosts separate leases where they're allowed to sublease, and then having them sublease to the short-term rentals and having them apply. How about rentals for 32 days? So the TOT is only due for rentals 1 month or less. The licenses are only required for 1 month or less. 32 days is more than a month. Is this a loophole?
I would agree. The only problem that you end up with is you've got 32 days, and then you've got the next calendar month, and then how are you going to keep working through it? But it does allow you a way to get around the requirement under the ordinance.
Yeah. Well, my last observation is that assuming this may take several of these short-term rental agencies, these corporate agencies out of the market, maybe there are more licenses available to individuals to do short-term rentals with their homes. Maybe there's less competition than we think if you're taking a bunch of these corporate agencies out. Well, let's get into some of the basic reasons for the licensing requirements. So I think it's commonly understood, a commonly held principle or premise here that there's a California housing crisis. Do you agree, Dennis?
I definitely agree.
And so that would tend to indicate that we need more housing for regular people with regular income. There are too few units for the number of individuals and families in San Diego County. I think we can presume that to be true. Do you agree?
Yeah, I think it's pretty clear. I mean, some of our clients that we have actually build affordable housing projects. So I see numbers all the time that talk about the housing crisis within the city and the county of San Diego. So there's a clear issue between affordable housing, if you will, what I call a capital A, and then the affordable housing of the folks that may not qualify for that, but can't afford to go out and buy a house with a median home price of where we're at right now. Even in the current economic times, is our median home price is vastly larger than in most other areas of the country. And so we have large population of people without a house living here, not because they can't pay their bills, but they can't afford the house. Other than I can pay everything else, you just can't afford to buy and rent the house.
And I'm not talking about homelessness right now. I'm just talking about people who are working, who have income, who just can't afford a house. I think, are you talking about that population as well?
Yeah, I'm talking about that population, the folks that have jobs that are working in our community and they can't afford a place to live.
So in your practice, you're helping to build affordable housing. How do you think even with the state helping your clients to build affordable housing, sorry, that threw me off 1 sec, and my battery is running low, so I have to plug in my computer. But do you think that it's possible to build enough affordable housing to house everyone in California?
Under the current conditions and the current way we operate, no. We have large amount of regulations that dictate what you can and can't do. We have an extremely lengthy process with regard to review in order to get permits issued to build in the city of San Diego and in the county and other cities within our vast community here. The cost of entry is steep if you're trying to build, even if you're trying to build apartment buildings, a 5-story apartment building, it's steep. We have made strides. There are things that are going on. The state has dictated that if you're on search and transportation corridors, you get additional units and the city can't deny you those units. If you add certain affordable units to a building, you get to double up on those units. I mean, in Mission Hills, a neighborhood that I'm familiar with because we live there, there's a building that was done. They added 5 affordable units and they got an additional floor to add to that building because of that. So there are those things we've done, but we haven't brought the barriers down sufficiently to allow us to build the number of units necessary for us to house the folks that we have living in our community right now.
So I just saw an article, November 12th, NBC News published this article about the University of Southern California, Lusk Real Estate School. Mm-hmm. They're predicting rent hikes in San Diego in the next 2 years that exceed Orange County and Los Angeles County. But I also saw an article, a comment in the news that San Diego is doing really well with building more housing. In fact, we're doing better than most other cities in California. So why would we be the ones getting a higher rent hike?
Well, part of it is, and economists can do this better than I just use it based on the anecdotal work of our developer clients. Part of it, the reason is that even though we are doing well in developing more apartment and other housing units in the city, we still are not at a point where we are building sufficient numbers in order to house everybody. And as costs continue to go up with regard to construction and other activities, rents are going to go up. And as much as people look at the number of people supposedly leaving the state or leaving the city of San Diego or relocating, we still have more people here and the demand is higher here than actually and it doesn't surprise me that we have a demand greater than in Orange County, given the size and the growth of our population within this county and the job opportunities that are here. You just have to look around and see how successful UC San Diego has been and San Diego State have been, and the things that San Diego State is planning with regard to Campus West. We have the stadium in place, but we have not yet seen the expansion of the university. And when we see that, more is going to happen. And we're doing well. We're not keeping up though.
You mentioned that the college housing crisis is really even a separate housing crisis than the overriding California housing crisis.
It is. If you look at every university or college we have in the San Diego County region, none of them are able to house all of their students. Now, we know there's certain populations that won't be housed. If I'm getting my PhD, UCSD is not going to house me. I've got to go and figure that out because I'm not part of the undergrad system. But we don't even house the undergrad system. And UCSD has had a tremendous development process in the past 4 or 5 years. They're building huge numbers of apartments. And even after that, they still won't be housing all undergrads at UCSD.
Wow. Well, it's a complex issue. I know that a lot of the solutions proposed at the moment are tax hikes, where the increase in taxes will go toward solving some of these problems, homelessness and increasing housing for people with lower income. And I've also heard that, it's the people who are being priced out of the market are the people with low income who are willing to do those jobs that pay less, those being labor jobs, working in the kitchen of the restaurants, doing those things that, practically speaking, those jobs just don't pay enough to afford housing here. And the problem this creates is that it increases the cost of everything for the rest of us, because ultimately just to get enough people working, the employers have to pay more for them. So it's a complicated issue. I think getting back to the licensing issue, the short-term residential occupancy issues, is it solving any part of this problem? Now, I would say yes, because it helps the housing shortage, because in these areas that are more impacted, where the number of licenses are limited, there would be more units now available for families who need a full 365-day housing, people who would not be using the short-term vacation rentals. So there should be more units on the market. Do you agree?
I have a different position. I say no. The length of time within terms of the short-term rentals is too short. So people are going to have to continually move and move and move and move. So we haven't really done anything other than port people around. It's not solving the problem to increase the amount of housing that's available on a long-term basis to allow folks in those economic zones and economic areas you're talking about, the folks that we have and rely upon for all kinds of things, from taking care of our lawns to waiting on us when we go out to a restaurant, to actually have a place to live. So my perspective is different with regard to that in terms of what this is solving. And I don't think it does solve our problem.
And, I've asked you some questions that get more into economics. You and I are real estate attorneys, and we're talking about theory here, because we see things from a different perspective sometimes than everybody else, because we're working with people to try to utilize these things. And I think I forgot to mention at the beginning of the webinar that we're not giving any legal advice. We're talking about general situations, and any particular situation would need to have a one-on-one conversation with an attorney to provide actual legal advice. But yeah, in theory, I think you're right. There's this interesting angle that some folks had where you'd rent to a college student for 9 months of the year and then do short-term rentals for 3 months of the year. And I thought that was a very interesting business model, but now is it worth it to try to do that if you have to jump through all of these hoops to get a license? I don't know. I mean, I think probably some people will.
Yeah, I think it comes down to economics in terms of where the rental unit is in proximity to a university that makes it convenient for a student, but is also in proximity to an area where during the 3 months, presuming we're talking about the summer months here, that a student is not going to be occupying that space, and it'd be a place where folks would want to come from outside of San Diego or even internally and want to vacation there for some short-term period of time. So I think it's a balancing act in terms of what economically would work for you, and you have to look at those. I think at least those two conditions.
Yeah. And certainly there are other purposes served by the licensing. Many would argue that communities are improved by fewer transient occupancy folks, fewer vacationers, that, sometimes the people who are utilizing those vacation units are not the people who are voting in that district, and not the people who are using the schools in that district or need those other facilities that those of us who live in these areas need. So is it causing problems? So, I mean, I think the next big question is, does this cause more problems? You mentioned that there are folks who have residential units on a commercial zoned property.
Yeah.
How are they impacted? How does it apply there?
We have a client that has property that is in Pacific Beach that is zoned commercial, but on it sit 8 residential units. And typically during the summer months, obviously its location would kind of gear you towards trying to rent those things for short terms for those 3 months, and for 9 months of the year, renting them to someone else, whether it's students or otherwise. But this ordinance doesn't really care about the zoning of your property. It only cares about the actual use of the structure. So in this case, when you read the ordinance and you look through the rest of the city's ordinances, you realize that those folks, this particular client, is not going to be able to do exactly what they've been doing in the past, because they can only have one license, and it doesn't matter that they're in the commercial zone, because the property is being used residentially. So zoning is no longer the issue with regard to this particular ordinance. It's use of property.
And in order to convert their building into a commercial building, such as a hotel, how hard would that be?
Extremely difficult. If you look at your own home and take a look around and what's in it, and you walk into a hotel and understand what's going on with regard to things like life safety, where sprinklers are involved in addition to fire alarms and other kinds of things, you end up having to expend an extreme amount of money to bring those facilities up to meet the ordinances that we have with regard to hotels. We have specific ordinances in the city of San Diego and elsewhere that talk specifically about what you have to do and how you have to operate them. My house would not qualify without a whole lot of work.
So I think that people who have been doing vacation rentals and doing them well are particularly impacted, because now they're limited to just one license, unless they can finagle something to get more licenses. They can't be an entity, which you mentioned, and I thought this was very interesting. If you're an individual and not a corporation, you're not shielded by your corporate entity. So you become personally liable for everything. So, in most of these vacation rental situations, do you think that the new hosts are going to feel comfortable with that if they once operated as a corporation and now they have to operate as an individual?
So one of the things that would happen if they came to talk to me would be a long discussion with regard to exactly what you're talking about. The fact that there's no longer a shield that allows you to put risk associated with operating that property into one bucket and your personal life in another bucket. In this case, you now have to mix those two. So it brings up issues associated with insurance. Have you got insurance that will cover this type of short-term rental? Or there are exclusions in your policy? Have you looked at the definitions? You need to have someone that knows how to look at those things and walk through them to figure out what you're going to do, because you're going to need to have some kind of protection against the fact that, it's not inevitable, but people do slip and fall on all kinds of things. And no, we don't have ice here in San Diego, but we have water and other things. There are things that cause people to fall down and get hurt. And so that brings up the issue that you're just talking about, and you have to be very careful. We no longer have those protections for our clients.
I would suggest the use of a property management company, because if a property management company is the name on that contract with that short-term renter, if the property management company is the one, advertising the property on Airbnb and making that direct contact with the renter and acting on behalf of that individual host, it's possible that the name of the individual host could be completely out of the picture. The property management company could be on the contract. They are the one who receives the payment. They are the one who receives any complaints or suggestions. And so maybe the shield now becomes that management company. And I think that's highly advisable to use the management company.
I would agree.
Those platforms. So the platforms are interesting. Airbnb is a platform. VRBO is a platform. The law, I'm not going to say the law protects the platforms, but the law exempts the platforms from liability for things that happen between the owner and the vacation renter. So you can't sue VRBO for things that VRBO really didn't have anything to do with. So the owner doesn't provide the property the way that as expected, or something happens at the property, VRBO isn't responsible. But the platforms just facilitate the connection between the owner and the renter. And they also don't care whether you have a license or not, but they probably have a little box that you have to check when you place your property on the platform that says, yes, I have all applicable licenses and authorizations to rent this property. All right, so we're getting toward the end, and there are a couple of questions posted. My last question for you, Dennis, what's worse for the San Diego economy? The loss of vacationers and vacation units, or the lack of housing?
Lack of housing is, to me, much more critical than the loss potentially of vacationers. We have people that are living here full-time doing all kinds of things that actually provide ways for people to become vacationers and come here. But the lack of housing ends up, as you described earlier, folks that earn at a certain income level can't afford to live where they work. And that causes problems. And if those people leave, we don't have them anymore. We really need to house people first. And if we're able to house them first, the rest of those parts of our economy will, in fact, stay robust and keep moving on. So I believe that the housing shortage is much more critical and the thing that we should be concentrating on.
Yeah, I 100% agree with you, Dennis. I think that the loss of diversity, the loss of the scale of different kinds of people in the community is a huge loss for our San Diego culture and our San Diego economy. And so hopefully we can figure out a way to fix this. Although I don't know that the licensing of these vacation rentals is going to do it. I think that the solution is in building more units and finding more ways to to create infill and create density in the housing market so that people can do what they need to do and afford to live where they need to live.
I agree. There's probably a couple of other things people should quickly pay attention to with regard to, we talked about the licensing thing, but if potentially you may need to have a business license within the city, so you need to pay attention to that. If you have a condo you're trying to rent out, you have CC&Rs you've got to deal with. Some of the cities actually with ADUs have a cutoff in terms of when they've grandfathered them in or not. So you need to talk with folks like Shanna in order to make sure you know, and know that you're doing things correctly. We've made things complicated again, so.